Watching News at Prime, let's bring you this now. The Pretoria High Court has dismissed an application by accused number 4 in the Senzo Meyiwa murder trial, Mthokoziseni Maphisa, to have the charges against him withdrawn. Maphisa filed an application saying that the state had not met the threshold to have him answer to the charges, but the judge, Ratha Mokgoatlheng, dismissed his application, and Maphisa, including the 4 others, are on trial for the 2014 murder of the soccer star. The trial will now resume on the 22nd of September. All right, let's quickly get some analysis around this and whether it's a win for the state. Joining me now is Ulrich Roux, a legal expert. Ulrich, good evening to you. Thank you, as always, for taking time out to talk to us about these things. From the get-go, the instructing attorneys, and I say that with a bit of a smirk on my face, because basically the gentlemen accused here are being represented or paid for by legal aid. Legal aid said there were no prospects of success in this particular application, so they were not really going to fund this. Was this the outcome that they should have expected in any case, at least accused number 4 who's trying to get discharged?
Hi, good afternoon, Toli. Thank you for having me. Yes, well, certainly, attorneys are creatures of instructions, and we act on the instructions of our clients. And if the accused number 4 was adamant that his attorney must bring the application in terms of Section 174, then those were his instructions and he acted accordingly. So, the judge made it very clear during his ruling today that he regards the evidence led by the investigating officer, as well as the evidence corroborating that, the ballistic evidence and the photographic evidence, as being a prima facie case that accused number 4 needs to answer to. And he accordingly dismissed the application in terms of 174 of the Criminal Procedure Act. I think just to explain to the viewers what that is, remember that a criminal trial entails essentially 2 parts. It is firstly the state that presents its case against the accused, and then the accused gets an opportunity to rebut the allegations that has been leveled against him. The onus, however, is vastly different in that the state needs to prove a criminal charge beyond a reasonable doubt, whereas an accused only needs to prove that his or her version is reasonably and possibly true. Now, what accused number 4 argued today through his lawyer or in bringing this application is that the evidence of the state is so weak that, in fact, only based on the state's case, there's no case for him to answer to, and there's no incriminating evidence which implicates him in any wrongdoing in this matter, and that the only result of him having to present his case and him having to possibly testify is that he would be incriminating himself. The judge found otherwise and said that there is evidence that links him to this crime that has been presented by the state, and that he needs to hear what his version is, and what case he is going to present as accused number 4, and then make an objective decision after having considered all of the evidence before the court.
Ulrich, it goes without saying, unless, of course, there are those of us who may be in doubt about what or who legal aid is, this is basically the money of taxpayers who pitch in when people do not have money to hire their own lawyers. Now, again, let's reiterate. Legal aid came and said, we're not willing to fund this because the prospects of success are very, very slim. So here we are with accused number 4 having lost this case. Who's going to foot the bill?
Well, that certainly is an interesting question. Remember, legal aid is attorneys that are made available by the state in order to represent people who do not possess over the funds to pay for their own lawyers who they can instruct in their personal capacity. So essentially, an accused person who is represented by a legal aid attorney does not pay for those legal services. Legal aid, however, are able to contract private advocates and private attorneys to act on their behalf as well, And then, as you correctly point out, taxpayers' money will foot that bill. Now, I don't know the intricacies of what legal aid has said. That's the first that I've heard of it, so I cannot really comment on that. But if they said that they are not footing the bill, and accused number 4 instructed his attorney to proceed nonetheless, then one can only expect that he should be footing the bill. If there was an agreement reached that should it be unsuccessful, that he would be paying for this. But that would be an arrangement made between legal aid and accused number 4, and I would suspect that is a privileged arrangement or agreement that has been reached between them.
Very interesting turn of events. And as we conclude, Ulrich, I suppose it goes without saying then that the case will indeed go on full steam ahead on the 22nd of September with the accused, I suppose, having to prove the state's case weak in their words.
Yes, well, as I said before, the state needs to prove a case beyond a reasonable doubt against an accused, whereas an accused only needs to prove that his or her version is reasonably and possibly true. Now, it is not for the accused to prove their innocence. It is for the state to prove the guilt of the accused. So one can expect now that all 5 accused would most likely testify in their defense. And then they will, of course, be subjected to cross-examination by the state in order to determine whether their testimony is in fact credible and whether they are telling the truth. It's certainly going to be interesting to see how they address the allegations that have been leveled against them, and as well as the evidence that has been placed on the record by the state. As I said before, the photographic and the ballistic evidence is quite incriminating, as well as the confessions that have been submitted into the record. There was a trial within a trial held, and the court found that those confessions were made freely and voluntarily, and it's difficult to get around those confessions once the court has already found that the confessions must be accepted and that the accused were not placed under duress in making them. So certainly going to be interesting, and one can only hope that it's going to be concluded swiftly. Senzo Mayowe was murdered in 2014 already. This is now the 12th year since his death, and I think society wants to see this matter concluded, and if the evidence proves that the accused are guilty, then they should be convicted, whereas if they present a case that is reasonably and possibly true, then our law dictates that they should be acquitted. So certainly interesting testimony that awaits.
Ulrich Roux, thank you very much indeed. And you end this conversation on a perfect note, because this is a long-running trial. I think everyone, not least the family of the deceased person here, Senzo Mayowe, they want to see a conclusion of this case. Thank you very much for your time this evening.